Thank you. Thanks, Liz. Thank you, everybody, for being here, and for the people who are online. This is a fascinating topic. There is a lot of substance here, so we're just going to dive right into it. And as the introductions indicated, we've got somebody who knows a lot about the plaintiff's side, somebody who knows a lot about the government plaintiff's side, and somebody who knows a lot about the defense side of unfair trade practice claims. And so let's start with Kelly. Maybe you can start, but can you begin by describing, for our audience, sort of the nuts and bolts of the work you do under the Uniform Trade Practices Act? And first, maybe as a reminder, start with a quick review of what constitutes a violation of the UTPA.
Sure. So for the government's role in the UTPA, we've been, I don't know if a lot of people know, but before the UTPA, Oregon had, can people hear all right, a deceptive trade practice statute that was only enforced by DAs up until 1971. And obviously DAs couldn't keep up with that. And so there was no private right of action. It was just criminal enforcement. So in 1971, they passed the Unlawful Trade Practices Act in Oregon, and it gave the AG authority to enforce violations of this new act. And we've been doing that since it's a law enforcement function. It's a little different than in private practice. Our goals are a little different. Our tools are a little different. We operate under some different provisions of the statute that nobody reads when they're private practice. I didn't, before I came to DOJ, didn't even realize they were there. In 646, 632, and 618. And we'll talk about some of that as we go. But our role is a law enforcement function. We're functioning as civil prosecutors. We don't represent individual consumers. We don't give them legal advice. We're not taking their cases. It's not like a form of legal aid. Our job is to force compliance with the law. And so our primary goal is to investigate and prosecute violations of the act. We have an array of investigative tools. We'll talk about investigations in a little bit, but our purposes are a little different than when you're in private practice. So what we're looking at is what's called specific deterrence and general deterrence. We have deterrence goals. We want to get companies into compliance with the law. If they're violating, we want the violations to stop. We tend to be heavily focused on injunctive terms, which is a little different than when you're private practice and you just care about the exchange of money and the release. Our settlements often have extensive injunctive in terms because we are interested in making sure that those violations don't recur. So when we're bringing a case, we're also interested in punishment, essentially. We want to deter conduct. So it's not enough to say give back the money that you wrongfully gained or to say stop the conduct. That tends not to deter. So there has to be some consequence when you violate the law, and the legislature has determined what that is. We'll talk about remedies a little bit more, but the penalties under the UTPA are fairly significant, up to $25,000 per each willful violation. So that can add up quite a lot. And it's a little different than in private practice. We also seek restitution on behalf of consumers. Not all cases are well suited to restitution. It's not unusual for there to be a parallel class action, and restitution will come in from the class, and we'll be focused on penalties. But ultimately, the policy goal is to get folks into compliance with the law. We have a different set of investigative tools. I sometimes make the mistake during interviews of telling lawyers, because they can connect to it, that we get to do pre-litigation discovery, because they kind of understand what that means. But that's not really what we do. We're doing an investigation. You don't want the government to just decide that you've done something wrong and sue you out of the blue, unless there's an actual emergency situation. We generally conduct investigations. They last several years in most cases. They're very document-intensive investigations. And in most cases, they'll result in a negotiated agreement. Something called an assurance of voluntary compliance, sometimes a consent judgment. In some instances, we end up filing litigation. But in most cases, we're doing investigations. We have some special tools under the statute to do that. And a lot of our work is actually done in coordination with other law enforcement partners. We work very closely on a bipartisan basis with other state AGs. A lot of our work is multi-state investigations where large coalitions of AGs, sometimes 20, 30, 40, or even all of the AGs will join together in a large investigation. It presents its own unique challenges, having 30 or 40 or 50 different sovereign states led by political officials with different political views to get them all on the same page. Obviously, when you take on 50 states at the same time, that can also get very document intensive. It can get very complicated in terms of what kind of relief to seek. But a lot of our work is done in cooperation with our partners. When I got to DOJ, I think about 75% of our docket was multi-state practice. Multi-states present some other challenges for offices because most of that work goes on behind the scenes. And we have extensive agreements in place when we're doing that work that mostly keep it out of the public until there's a settlement. So oftentimes people are poking at us saying, why aren't you doing anything about this issue? And we just can't tell them that we are, but they take a long time. Most multi-state settlements take 3 to 5 years. Some once in a while will take longer. So it's a long process that goes on. These are big, complex cases. They cover the whole range. We also partner very closely with the FTC, with the CFPB. We are the state's law firm. So as you can imagine, we have relationships with just about every state agency, board, or commission in the state of Oregon. And in their respective areas, they constantly see violations or issues that they can't address. And so they come knocking on the door almost every week. We have a consumer complaint process where consumers can file complaints. So we are sometimes getting information directly from the marketplace at the same time. AGs are very public officials. They're regularly visited by industry groups, consumer groups, civil society groups. We hear from the media. We hear from legislators. So it's sort of a strange thing. When you're in private practice, you have a specialty or you have some things you're known for, the kinds of cases you take. And so people bring those kinds of issues to you, and that's the world that you see. When you're government, everything comes to the door. Everybody contacts you. There's almost not an issue that's occurring anywhere in the marketplace that somebody's not reaching out to us to take a look at. So very big challenge of government is how to allocate your limited resources to match what the needs are at the time. And we're going to talk a little bit about that at some point. Our cases are a little bit different even when we bring them. It's a law enforcement function, so we don't have to wait until somebody's harmed. This is a little different than private practice where you're seeking compensation for the harm. I don't have to prove, for example, ascertainable loss to bring a case. Why is that? Well, think about it this way. If you saw somebody driving recklessly down the freeway, the officer can pull him over. He doesn't have to wait until he hits somebody or kills somebody. We don't have to wait until enough consumers are harmed by the practice to take action. It may affect the relief we seek, but we still need to act in some cases. So we have little different elements. But we don't only have advantages. We also have disadvantages. So unlike private plaintiffs, under certain circumstances, we can be subject to attorney's fees if we sue and lose. And that comes out of the state's coffers. So it puts a different spin on the cases that we take. Some of the elements are also different in a case. So for example, there's a statute that provides we don't have to prove actual confusion or misunderstanding in a deception case. So the cases, again, have a different focus, a law enforcement focus. We're focused on getting people into compliance with the law. And we have a sort of secondary focus on things like getting money back for folks. I think that's probably good.
Yeah, Nadia, why don't you hop in now and maybe again, I would tick through the elements, including what is an unlawful trade practice.
Yeah, sure. So I represent individuals under the UTPA's private enforcement mechanism. As Kelly talked about, the UTPA has a sort of dual enforcement scheme, which many of you I'm sure are familiar with, where it has a private right of action for individual consumers to sue private corporations. And then it has the public enforcement action where AGs can enforce the terms of the UTPA against also against corporations and other actors. The UTPA, there are several provisions of the UTPA that provide sort of a laundry list of violations. In my world, I operate under 646, 608, which are the laundry list of violations that a private litigant can allege in a private action. CLE has a sort of a broader list, a laundry list, in the sense that there's a separate provision with additional violations that the state can sue under. But 646, 608 lists out, do you know how many? 70 something, 72 or something like that, different violations that range from very specific things like you can't sell mercury thermometers to you can't create a likelihood of confusion in the marketplace by a representation that you make in the sale of your good. You can't make a representation or a misrepresentation about the geographic origin of the product or about the nature of the product or the nature of the good or services. So there's a huge laundry list of violations, and then a private right of action under 646, 638. That private right of action, like I said, allows any person, but person is defined to exclude public bodies. So any person can sue another person for a violation. And when they do that, the person, well, let me back up a second. Any person who suffered an ascertainable loss that Kelly mentioned, as a result of another person's violation of the UTPA, has a private right of action. That private right of action provides for actual or statutory damages, whichever is greater. And the UTPA also has a specific provision for class actions. I always say that is for very good reason. I teach my consumer law students that it's for very good reason, because as we all know, a lot of the violations that we see in the consumer marketplace are very small dollar violations, and they result in small damages. And sometimes the only way then to hold somebody accountable for the violations that they cause or the damages that they cause to consumers is to bring it in the form of a class action where you can aggregate the damages and hold that actor accountable. In my practice, we operate primarily under the private right of action and primarily as in class actions. In those class actions, we're in the damages world, unlike the state, which is often in the restitution or the injunctive relief world. We are allowed to seek injunctive relief, and we do so routinely in our cases. So we ask not only for the $200 per violation, which is the statutory damages that the UTPA allows for class actions, but we also ask for injunctive relief, stop the practice, and that's always part of our cases. The class action provision also allows, or the UTPA also allows for attorney's fees in class actions and private class actions, which not only class actions, but also private, individual actions, as an incentive, again, for consumers to be able to bring the claims when they suffer loss as a result of a violation. Sometimes, and we'll get to a lot of this stuff later, sometimes
yeah, we're gonna go through this, then we're gonna come back again multiple times. So you don't have to say everything right now.
Okay, perfect. I'm gonna stop there. There's a lot more to these private claims that are advantages and disadvantages to bringing private claims into the UTPA, but we'll get to those later.
Tom, now now the fact that there are two of them and only one of you doesn't even mean you get twice as long as they do.
No.
Okay. So tell us a little bit about defending these actions, and maybe explain a little bit more about how you would approach a UTPA claim brought by, or an investigation by DOJ, as opposed to a private class action that gets filed against one of your clients.
Sure. So I think, as Kelly mentioned, and I'll talk a little bit about both a public enforcement and a private action in answering the question. But as Kelly mentioned, and it's not just in the public side, also on the private side, when you get a notice from Nadia under ORCP 32H that they're going to bring a class action, or if you get as Kelly mentioned, a CID, which is basically their initial document request in the investigation, a civil investigative demand, you understand that in for a long road, right? As Kelly mentioned, these cases can go on for a long time, and they may be able to be resolved quickly, right? I mean, there's a mechanism within ORCP 32 to respond to that demand and provide the restitution or damages to resolve the case. That doesn't, typically happen, and I think it was made more difficult by a recent Court of Appeals opinion to achieve that in a private case, which we can talk about. But so we know that it's going to be a long haul. So, a lot of the typical things that you would find in any litigation apply here. So, you initially have a document preservation obligation. And it's made a little bit more complicated, I think, in class actions, consumer class actions, or in state enforcement actions, because you don't quite understand, how big this is or how small this is, right? I mean, how big is this class? So, what kinds of custodians are we actually talking about? So in terms of document preservation, in my experience, you're generally communicating with the plaintiff's attorney or the state a little bit more about those issues right at the beginning. But then you're thinking same thing you're thinking in any case, right? What court am I in? Do I want to be in a different court? Right? Do I want to, if we're in state court, do I want to try to be in federal court? Can I be in federal court? Is this the right venue? Do I want to get complex case designation from the judge? If I'm in state court in a class action UTPA case, I want complex case designation, because I want a judge that's going to be there for the whole show, and will know the case and just kind of understand the issues and how they've developed. And then you're just doing your investigation. I think in a UTPA case, whether we get something from the DOJ or we get something from a civil plaintiff's attorney, I assume right off the bat that they know a whole lot more than I do, right? Maybe this client I've worked with in the past, maybe I know this industry, but I assume that they have done their homework. Natty is not going to bring a lawsuit unless she does the legwork in advance, right? So I need to kind of catch up at that point to where she is. So I need to start talking to the company. I need to understand this market, because I know class issues of reliance and class issues of how a purchaser thinks in this market. That's going to be very relevant to, which is, as we'll talk about, I'm sure just, class certification is going to be a major event. I need to understand very quickly, from the company's perspective, hey, when you're selling a product, how does your consumer make the decision about buying your product? What kinds of factors are they thinking about when they're making their purchasing decisions? Because that's all going to flow into reliance, as both Callie and Nadia talked about. There are really three elements here, right? You have a ascertainable loss as a result of a violation of the UTPA. And so, when I think about as a result of, I'm thinking about causation, I'm thinking about reliance, and I know that's going to be a big piece of the case. And then I'm thinking about what my defenses in the case will be, not just on reliance, but if a violation of a statute or regulation has been alleged, thinking about, okay, what was the rulemaking process for that regulation? How did that regulation come about? Did my client have any role or offer any testimony as a part of that rulemaking process? I want to know that. I want to know what their policies were in that area, so I understand, did they comply with the statute? Or the regulation? Were they aware of it? So I want to know all of that as quickly as I can. And that's all going to play into, a host of defenses that you might have, including a due process defense at some point of, what was my client's good faith compliance with the UTPA violation that's being alleged.
Great, thank you. Let's drill down a little more into some of these topics that have been touched upon. And Kelly, maybe you could tell us a little bit about DOJ's process and whether you think it's going to change with the new administration in terms of bringing an enforcement action. And you've got limited resources. Which sort of cases do you want to bring? You've alluded to this before, but how much of your work these days is national as opposed to more local, and how much is driven by consumer complaints? You have a very robust consumer complaint reception function, and I know you're trying to help individuals there, but you're also presumably monitoring where are people finding problems in the or finding what they think are unfair or fraudulent practices in the marketplace as a way perhaps of looking at the kinds of cases you might be bringing.
Yeah. So maybe I'll start kind of with capacity and how we're organized, because it drives a lot of other things. But I also find that folks, when they're interacting with us, are often confused, both on the business side and the consumer side. The department is kind of split into two halves in a sense. We have our enforcement work where the attorneys, investigators, and paralegals are. We presently have 7 attorneys. There's another attorney that has been working on the opioids cases, is over in our antitrust unit. There's some separate privacy resources over in the antitrust unit with the new statute that was passed. But for the core consumer protection work, the enforcement side, which operates out of Portland, is 7 attorneys. We're actually hiring, and hopefully we'll be at 10 again by the end of the year, and hopefully get some more positions after that. But it's a rather small department. Just to give you a relative point, we're not among the smallest agencies for AGs, but obviously California is huge, biggest in the country. You would expect that. But Washington, our neighbor to the north, who folks often do comparisons with, they've grown tremendously in recent years. And when Bob Ferguson came into office, they were about the same size we are. They are today an entire division. They are 124 FTE. They are 55 lawyers doing just consumer protection work. So we're not going to take on that scale of scope of work. So enforcement resources drive a lot of what the agenda is. That's on the enforcement side, but most of that takes place, the cases themselves are taking place outside of the public eye. The other thing that people see, though, is our complaint process and our public-facing programs that operate out of Salem. We have a consumer advocacy manager and non-attorney manager who manages those day-to-day. We operate a consumer hotline. We get there's a full-time employee and volunteers from the community who help out with the hotline. They get 10,000 calls a year. They get about 300 emails a week on every single subject that you can imagine. And they're trying to help people figure out, is there another agency that can help them? Is there another part of DOJ? Is there some general information they can provide? But the sheer scope of that it's hard to imagine when you're in private practice that, one call could be about a lending issue, student loans, some detailed issues. Somebody else may be asking about a car dealer. Somebody else is asking about gift cards and gift certificates and what's the difference. It's everything. We also have a consumer complaint process. Whether you're on the consumer side or the business side, you may interact with it now and then. It is non-attorney staff. Depending on which analogy you can relate to better and your own experience, you can think of it kind of like the BBB, or if you're used to legislative side, kind of like constituent services for a legislator. It's an informal dispute resolution process. Obviously, thousands of consumers have, as Nadia mentioned, small issues that they need help with, and they're often kind of looking for a way to resolve them. So we get about 9,000 complaints a year. It's actually down. We used to get thousands more than that. And they go through an intake process. If it is better referred to a state regulator or a federal regulator, it'll get referred. Sometimes people are just sharing information or tips with us. Want us to know about something they're seeing in the marketplace. They'll get an acknowledgement letter. But if there's a dispute between a consumer and a business that we think we might be able to help with, That'll go out to a copy of the complaint will be mailed to the business. The business has an opportunity to respond. They'll be assigned to a non-attorney staff person who's working with the consumer and the business to see if they can get that problem resolved. Big companies are smart about this. They understand that this is out there as a public record, that if they're not responding to complaints, they may actually get AGs interested. And so they often have special escalation contacts. A lot of consumer problems just get resolved just with a simple call. If they don't get resolved, then the consumer's going to have, we don't represent them. They're going to have to go get a lawyer. They're going to or go to a small claims court or do a chargeback or find some other way to resolve the problem. We won't be able to resolve all of those. But we get in exchange a lot of information about the local marketplace in particular. It is not a representative sample of what's going on in the marketplace, though. It is self-selected. Studies have consistently shown for years that about 2 to 3% of all consumers will complain to any organization when they have a problem. So that's all state and federal agencies, the AG's office, the BBB, all of it combined. So very few consumers ever end up complaining. Far less than 1% of those ever go to a state AG's office. And it's a self-selected group. If you're representing a business and you get one of these complaints, a couple things I recommend you keep in mind. They're all public records. Those consumers are a self-selected, particularly assertive and upset group. They tend to write their legislators if their problems don't get resolved, sometimes all of the legislators. They go to the media when their problems don't get resolved. Media requests not just those complaints, but when they're hearing about an issue, media regularly does stories on consumer protection. They're great human interest. So when you're writing a response or you're trying to resolve that issue, you should think about who that person is and is it worth digging in or just making that consumer happy and moving on. Legislators, when they come into session, they're looking at issues, are regularly thinking about and asking for consumer complaint data to get a sense of what are consumers in the marketplace experiencing. So I would be thoughtful when you're interacting with that process. I get media requests every single week. We get legislative requests when they're in session every week. These are going out in public records requests. So you advise your clients, to think about how that looks when they're sharp. And if we're getting a lot of unresponded to complaints or other things that may get escalated, we may be taking a closer look. We also have a bunch of smaller programs like the foreclosure mediation program that we have some responsibilities for. There's a telephonic seller registration program. So we have data coming in from those sources, but when we're setting enforcement resources, what cases we're actually going to take, obviously we can't take 9,000 random cases. They're not the best source of information. It's a one data point, but we have a lot better sources of information. We speak daily in all sorts of groups with other state AGs. We're hearing what's going on from all around the country. We're in regular communication with the CFPB and the FTC, with state agencies, some like DCBS, where we have a lot of overlap. We're in regular communication with. We're sharing information back and forth. Again, we hear from all of the state agencies, boards, and commissions. They bring us high quality information, often that's fairly well developed about a problem that we're seeing. Because we're the AG's office, whistleblowers contact us. So it's not unusual for us, as Tom suggests, we may have a lot of information. We often do have a lot of information. It may be that some other AG is also investigating the business, and we've done information sharing, and we've seen some of the information already gathered. So we often have a lot of information before we open investigation about what's going in the marketplace, but we are also visited constantly by consumer groups, by industry groups that see bad actors in their marketplace and don't like it, think that folks are giving them a bad name. So they come and talk to us. I think a lot more than people realize we hear from industry groups. We also hear from all sorts of other civil society groups. Some folks may be interested in animal rights. Some folks may be interested in the environment. There almost isn't a stakeholder that doesn't come and want us to use our consumer protection authority, which can be very broad, to try to figure out how to address some problem in the world. As you know, AGs are suing big oil in some states. States have brought cases about plastics. Obviously, tobacco was the sort of start of that. You see opioids. We've done privacy cases. It's very broad. What we're doing, but the resources are limited. So we have to decide out of all of that what to take. The thing that drives resource or enforcement resources first is the state AG. He's been elected by the people of the state of Oregon to make decisions and decide where to go. So, for example, under General Rosenblum, she was very interested in privacy throughout her administration. She made that a constant theme. She not only got the larger privacy statute passed, she sought a lot of smaller statutes. So we did Google. We led a multi-state investigation into Google. It is still the largest consumer protection multi-state settlement by AGs into a privacy case. It was $391.5 million nationwide. Oregon share that was almost $15 million. We led at one point what at the time was the largest HIPAA AG settlement that had taken place, again, because the Attorney General's priorities are in that area. So that'll drive a lot of where we put resources. Ellen was very interested in kid issues. Her last year, she was a president of NAG. Her presidential initiative was focused on kid issues. So it won't surprise you that we're one of the states that sued Meta and is litigating in the Northern District of California against Meta in the social media addiction MDL.
Just for those who might not know, NAG is the National Association of Attorneys General, right?
Yeah, NAG
or as they say, the National Association of Aspiring Governors is the one it's usually referred to.
Kelly didn't say.
No, Kelly didn't say that.
Let's be clear. Yeah, so the work we do in coordination, so TikTok, where we sued TikTok at the end of last year. They just filed their motion to dismiss on Friday. We're litigating against TikTok.
Well, what court is that in? Just
Multnomah County.
Multnomah County, okay. TikTok in Multnomah County, okay.
Yeah. Yeah.
Justice Baldwin,
sure,
can I ask Kelly
sure.
a question? So, so sometimes just on those just little
like
complaints that some individual makes, right? Then we'll get a client will call us and send us this letter where you all are passing on a complaint.
Yeah.
And so, we need to advise a client about whether or not to fight this thing, because sometimes the client will go, this is outrageous. Yeah. This is not, and lots of times the advice will be, hey, just, you know what I mean? Like, do you really want to, because, that consumer may call their legislator, or just, maybe they'll call Nadia, just, hey, maybe, try to resolve this, right? That's not always the advice, but that's the advice sometimes. Yeah. So, and then one of the things that a client will think of, as kind of a justification for, okay, well, doing that was maybe I'll get, some goodwill with the AG, just in, hey, we disagree with this, but we, hey, we're going to give your money back. Is there any legitimacy to that? I mean, do you guys often hear from the consumer that, hey, this was, resolved and we're good? I mean, you may see it in the letter that we write in response if we say that, but in general, does the consumer reach out back again and say, hey, they made good on this?
They do, yeah. And sometimes, if they're really upset and they think it was a rude response, they may be, asking the Attorney General and writing the front office, writing their legislators, and we may get asked, why aren't you looking at this? I'll give you some specific examples of what we do see and why you might want to pay attention. We had a few years ago during the vaping lung crisis, and we were doing Juul, but sort of behind the scenes, and this was an issue that a lot of people were concerned about. And we had a mom.
Kelly,
yeah.
Tom,
yeah.
I realize I'm the old person here and hard of hearing, but Kelly, you keep wandering away from the microphone.
Oh, well, I'll pull it closer. So we had a mom file a complaint. Her son bought some vaping products from an online seller. He was underage. And the online seller, their lawyer, instead of, they have an obligation to age verify. The online seller really didn't. And in fact, when we looked, they were mentioned all over websites where the kids were hanging out, exchanging information about which sellers to go buy from that you could get away with it. So instead of saying, gosh, this is really unfortunate, we're sorry this person's upset, here are all the great things we do to try to check ages and the things we're trying to do for compliance, and here's how we're going to respond, and try to make this right in the future. They sent a very snotty email, frankly, there's just no nice way to say it, accusing this mother of being a bad mother, and why wasn't she watching out for her kids, and what was she doing? And my staff was so upset that they said, Kelly, you have to look at this one. you know. So we did, and I was upset. I don't have kids; those aren't my issues. But even it was so outrageous. But what it told us was that this company isn't taking seriously its legal obligation. It's not just that a mistake was made; they really weren't taking it seriously, and they are selling to youth in Oregon. And when I looked, when I looked online, it was clear this was a real pattern or practice in an area that everybody was very interested in at that point. So I had an undercover shop done, and it was very easy. And so, yes, we opened an investigation. And not only did we open an investigation, but they got a different lawyer. And that lawyer was worse. I don't know what he was thinking. At the end of the day, the company had the opportunity not only to change its practices in an ABC, pay a very large fine, and they didn't want to pay the fine. So we gave them the alternative, go out of business. And they do not sell in Oregon. And if they at any time, it's a suspended penalty. So if at any time they were to decide to do business in Oregon, they will have to pay that penalty if we were to catch them selling immediately, in addition
So
to
the
any other
ABC is
yeah.
an assurance of voluntary compliance.
Yeah.
It's essentially non-judicial, but it's essentially an agreement, a contract.
Yeah.
Usually not filed, right?
No,
Unless
filed.
You have to enforce, they're always filed.
We filed them with the court. Technically, the court's supposed to approve them, but it's fairly rubber stamp. It's a settlement agreement.
The way
of
settling
form.
with somebody who's been the subject of a government investigation, with them essentially agreeing to take certain actions to resolve the complaint or the investigation.
Yeah, that's right. So, I mean, the response you give may make quite the difference. If it's shared with a legislator and they're offended, that may become a piece of legislation that your client may not like so much. If the media requests that, that may end up being part of a story in the future. So, like I said, you should take seriously when you get this complaint.
And then the AVCs are all public record, of course.
All of this is public record.
Right. And civil investigative demands, are they also public records?
Well, it all gets a little more complicated when we're talking about investigations.
Okay,
we'll talk about investigations in a little bit. But when we're setting enforcement resources, we do look. I mean, and we will get things escalated precisely because they stand out as an unusually bad actor, an unusually bad response. And when we're opening an investigation, we always go look at all of the complaints. We look at the responses from the business. Is it legitimate? And I will tell you that when things get escalated that do stand out, I will often ask as a special instruction, go ahead and process your complaint, but I'd like to see the response from the business. And sometimes that just takes care of it. It's clear there's just an honest dispute between these two parties. The fact it's an individual dispute, but once in a while you look and say, I think they need to be on the list. There's something of more concerning there.
Okay, so. Nadia, let's move over to the private side on the sorts of cases. What is driving the cases you're bringing? Is it people coming to you? Is it you hearing from class action counsel around the country and going out and looking for a plaintiff?
Yeah, I'd say, like Kelly, it's not one thing. It's all of those things. We certainly, there is certainly a national network of consumer lawyers, and especially those that work in several jurisdictions, and firms that work across the country. And we're very much connected with that network, as well as the National Association of Consumer Advocates and the National Consumer Law Center, NCLC, and NACA, both of which are organizations that are tracking issues that are trending nationwide or in certain areas of the country. And we try to stay up to date on what's happening with those organizations and what our partners are doing in other jurisdictions. We're also watching, much like Kelly is, the CFPB and the FTC. We don't have the same access, of course, that the state does to the officials in those agencies, but we watch what rules they're making, what guidance they're issuing, so that we're tracking sort of those trending issues. We can also look up consumer complaints and do. And so we know what, especially if we've got our eye on something, do not hesitate to go to the online database through DOJ enforcement and see if there have been any complaints filed and what those complaints look like.
Well, you want to give us a couple examples of what are ongoing cases now that have been recently filed that we may not have heard about, that either by you and David or other plaintiffs' lawyers here.
Yeah, so I'll give you a couple of examples of one of case that has been resolved and another case that is currently ongoing. The one that recently was resolved, and Tom worked on this case too, was a pricing case against Albertsons and Safeway for what we alleged were unlawful buy one get one free promotions on certain products in Albertsons and Safeway grocery stores in Oregon. And those are very straightforward pricing claims under the UTPA. We have another case that we filed that's currently ongoing against CenturyLink and Lumen Technologies for their Price for Life promotion, and with the allegation that for some consumers who subscribe to the Price for Life, their prices went up in their lifetime. So some pricing related cases like that. Those are two examples, and two examples of well, I don't know if I know exactly how those cases came to be, but I think there are two examples of cases. Actually, those are not sort of the types of cases that we plucked out of a national playbook or from our national partners and decided to file here in Oregon. Those are cases that came to us either by the consumer giving us a call, or a whistleblower giving us a call, or us just being on the ground and seeing what happens in the grocery stores and seeing the pricing scheme and the promotions that are out there in the grocery stores, and then taking the time ourselves to watch those things as they play out and keep track of those promotions as they play out. So the cases happen in a lot of different ways.
Yeah. Tom, from the defense side, have you noticed any trends in terms of the kinds of cases you're seeing? You see everything from the small cases, this individual consumer complaints, and the client is being smart and calling their lawyer first, or to the larger ones filed as class actions.
Sure. So I think as Nadia mentioned, we see, and some of this is just what we see, what we work on, or what we see, read about, or talk about, are pricing cases, right? I mean, you're always going to see those kinds of cases. And I didn't work on this case, but Kelly's office recently filed the AVC with Camping World, and that looked to be, the allegations were a pricing claim there that, if I get this right, Camping World had advertised a price, and then in negotiating with the customer had then added in costs and fees that were included in that advertised price to go on top of that. And so that was a recent settlement. We see, and it's interesting, Kelly, you said that, Bob Ferguson, when he was AG, had a huge office. So a few years ago, Bob Ferguson started investigating hospital systems in Washington on medical debt cases, and I think the AG in Oregon has some of those investigations. At least I've read about that. But then spinning
when you say
out
medical debt, what about medical debt?
So there are state laws about. I think people might be surprised at the level of, say wealth, but the level of income that someone could have in Oregon or in Washington and get if you go into the hospital, if you have certain levels of the federal poverty standard, you can't be charged for that debt. And so that Bob Ferguson was investigating a number of hospital systems, and then in Oregon that's happened. And then spinning out of that, there was a case filed a couple of years ago against a small hospital in southeastern Oregon, and then other cases have been filed. So we've seen those. I've also seen place of origin cases. That a product is advertised as coming from a certain area, and maybe it's manufactured somewhere else. I'm thinking most notably of Craft Brewers Alliance was a company located in Portland. It's now owned by, I think, Anheuser-Busch, but a number of years ago, maybe 3 or 4 years ago, they were sued in the Northern District of California on a place of origin claim, because the allegation was that they were in their advertising saying, "Oh, this is brewed at our brewery in Kona," when actually Kona beer is brewed maybe there, but also in a number of different states. So those are some of the types of cases we see.
Yeah, actually, Providence is a good example of how cases really come to be, because Ferguson did his case. We didn't know that was going on. And when he announced they were suing Providence, a reporter called our office and said, "Is Oregon looking at this too?" And now we are. Obviously, we opened an investigation and took a look, and have an ongoing investigation. You can find a little bit about that publicly from the CID fight. But obviously, there are also private actions going on in that space as well. And so that is typically what you see. An issue will get some attention. The CFPB has been very vocal about charity care practices lately too. So it's one of those issues that sort of ends up, whether it's local or national, isn't really a thing.
We're going to talk about, I'm going to skip over it for a little bit now, case investigations by private plaintiffs, the state, or defendants, and talk a little bit about litigation strategy. And Nadia, maybe you want to talk about I'm interested in Multnomah County being the venue for a case against TikTok, but when you're looking at that's not your case, I know. When you're looking at filing a case, do you want to be in federal court or state court, or and if so, why?
Yeah, we often want to be in state court, and we file in state court if we can. Some of our cases, we have a charity care case that's in federal court. We have a couple other consumer cases that are in federal court just because there's no other way to avoid it. But if we can, we like to be in state court. We like the pace of state court and the timeline through which we can get a case from filing to class certification to trial in state court, which tends to be a lot shorter, especially if you get, and we always agree with defense to get a complex case designation, so that we have the same judge that can help us move the case forward.
And do you choose your party, so it's going to be tough to remove it?
You try, yes.
You try, okay.
If we have that circumstance, yes, that's ideal. And then all the other obvious reasons for, there's no expert discovery, and there's the cases you can do a case for. Cases are less expensive in state court than they are in federal court, and we are a very small shop taking on a very big case. So those are some of the reasons. But I personally love being in federal court too, and I don't know that there's also some sort of the federal courts it tends to be more orderly and move cases along, and so there are benefits, I think, to both sides.
Will you get a judge in state court that has the experience in these kinds of cases that your average federal court judge would have, or no?
We do usually. Sometimes, there's a lot of new judges in the Multnomah County bench, for example, and so sometimes when you get a complex case judge, you typically get a judge who has a little bit more experience in at least the class actions or complex cases. Often there's an education component, and we're prepared for that, right? There's a need to educate the judge sometimes on how these cases work, not only under the specific to the UTPA, but just for class actions generally. Building in the case timeline that you need to get notice out, and all those things that need to happen if you get a class certified.
And Tom, you'd like to remove them to federal court if you can? And why is that? Because you get summary judgment more easily.
I think delay it? In general, I would say I would prefer to be in federal court, and that is, I guess, there are a few reasons for that. One of them is it's just a resources issue, right? It's not necessarily the judges at all, but a federal district court is going to have 3 or 4 law clerks, bright and bushy-tailed, just right out of law school, and then you have those people, looking at all of that and providing a bench memo to the district court about what it is. And I think all litigants, I feel like in general, and it is a resource issue. Lots of times you go into state court on a class cert motion, and the judge hasn't had the opportunity or time to kind of read through we're trying not to give the court a large stack of documents, but both parties, will tend to do that at class cert, right? Because it's a big motion. And just having an opportunity to kind of read everything is you get a better outcome. Typically I'm not somebody that says, oh, I'd rather have, expert discovery. I don't mind going into trial sometimes without expert discovery, but in a consumer class action case, it would benefit everyone, in my opinion, if you had expert discovery and have the opportunity to talk to somebody about what their opinion is, what's the basis for their opinion, and you just don't have that in state court. So yeah, federal court generally.
Yeah. Well, we do have state court judges who have a lot of experience with these cases. Judge LaBar is very proud of having actually gone to trial on 3 major class action cases in this or adjacent fields. And he used to say, and I used to use this line with federal judges I know who appreciate it. He said, LaBar would say, I'm just like a federal judge, but without the attitude. And most of them could understand that and probably agreed with it. Now, Kelly, you're suing TikTok in Multnomah County Circuit Court.
We are.
And why do you like to be in? I know you're in federal court with many cases in state court. Why that case in state court?
Well, state AGs strongly prefer suing in their own state courts. In fact, the amount of litigation we have in federal court is ahistorical. This is a really unusual period in AG practice. You will not see this normally, and I suspect things will trend back to the norm. Remember, we are a state, we are a sovereign state. Giving up your sovereignty and saying, I'm going to go to some other state and submit to some federal judge is just not how state AGs, there's a perceived advantage, whether it's real or not, there's a perceived advantage of being in state court. And for consumer claims, we're all bringing UDAP claims. So here UTPA, but other states have their own version of their unfair deceptive acts and practices statutes. They're all fairly similar, and we join together, but not when we go to sue. We've almost always separately then broken up, and we sue in our own state courts on our own state statutes. We don't really want somebody else deciding what our law is. And so it's the atypical part of seeing us suing together. Meta is highly unusual to see states bringing their state UDAP claims. We also have COPPA claims so that we could be there. But we that's just really out of order. And a lot of states had concerns about doing that. And if you've been following it since Law 360 is breathlessly following every CMC and DMC that happens, states are having some challenges in dealing with those issues. You become just a regular litigant. But we do also have, there's been a trend over the last few decades of giving AGs authority under federal consumer protection statutes. Congress doesn't have to pay for those, and it looks like there's somebody in addition to the FTC doing them. So they add us to everything. And so we have authority under a couple of dozen federal statutes. And so we're litigating under the TCPA in Arizona. All but 2 AGs are part of that litigation against an intermediate telecom provider. And then Oregon's one of the 5 original states, and now 11 states that are litigating against a consumer finance lender in the Eastern District of Pennsylvania. So again, federal claims, but not common. Most of the states did not. Oregon didn't. We did not bring our state UDAP claims in those cases.
You mentioned CMC, DMC.
Oh, the case management conferences, discovery management conferences.
I haven't been in court, trial court in a long time.
They're a lot of fun. So yeah, so as a sovereign, we don't, we prefer to be in our sovereign state.
We probably ought to just touch briefly on multi-district litigation. You're involved in multi-district litigation, presumably, and most of it's in other states.
Yeah, again, it's fairly unusual. Historically, there was a law review article out. I started at DOJ in 2017, and there was a law review article out. I looked at the time It was a mystery, I think, among consumer protection lawyers during the last crisis. Why didn't you see state AGs bringing cases under the federal statutes? And there's actually a host of reasons we don't. It gets fairly complicated in the weeds why beyond sovereignty, but states have been flexing their authority, I think, a little bit more under federal statutes. Some of it started under the Trump administration, I think. I think you saw more willingness to step in. There were concerns about early on the CFPB's willingness and ability to continue to bring cases. Obviously, the FTC has been a little bit hobbled in some respects by some negative decisions. And so I think you're seeing state AGs get more active. So we are in federal courts. What you're used to seeing state AGs on, I think the reason people think it's normal is the APA actions. So the so-called federalism cases, you saw Democratic AGs suing the Trump administration. You saw Republican AGs suing the Biden administration. But those aren't consumer cases or any kind of law enforcement action. You wouldn't normally bring those in another state.
Natty, have you had cases that have been pushed into an MDL circumstance or no? And
I have not.
yeah,
No.
and we don't have.
I try to
do we
steer
have
clear
any
of those.
MDL cases here in Oregon? Probably not.
I don't know.
Well, let's go back to the topic that I skipped over briefly, which is investigations. So, Natty, if you're going to bring a case, what sort of investigation do you do? You've mentioned some of the sources that you can look at. Do you look? You might have heard from a whistleblower. You might have heard from a former employee or a consumer or another small business, perhaps, that felt it was injured because of a UTPA action.
Yeah, that's a great question, and I want to go back to something Tom said earlier about when he was talking about what sort of the first steps he takes in defending a class action like this. And he noted that understanding how consumers make decisions and how the purchasing decisions are made in that circumstance, whether it's at a grocery store or online or what have you, how exactly that transaction occurs and how that decision is made is also something that I think on the plaintiff side, before Tom gets it, we very much focus on in our case investigation. And that goes back again to what Tom was talking about, which is that if we want to get a class certified, we have to eliminate or reduce the number of individualized questions in this case, which means ideally, we want to bring a claim on legal and factual grounds where we don't have to prove reliance in individual consumer transactions. And so that requires, if somebody makes an online purchase, for example, that requires, we go through and set up an account on, Safeway.com or whatever, and go through and make the transaction ourselves and understand exactly what the consumer read at the time that they read it. And any agreements that they made or any representations that they saw, we make sure we understand what those representations were in the context in which they were made. We have to do that so that we can be able to prove our case at the class certification stage. Beyond that, beyond just understanding exactly what the consumer saw when the consumer saw it, the investigations look a lot, I think, like any other case investigation. We have to be particularly cognizant of the fact that we have a class rep who needs to represent a class. And so again, making sure that their claims are typical and then eliminating individual questions about that particular person is important. And then sometimes more broadly, before we have a plaintiff or a class rep, if it's an issue that we're tracking, we are in the retail or in the stores taking pictures, stopping by weekly to check prices, things like that happen as we investigate our claim so that we know exactly how long a practice has happened, if it's gone on for a full year or 2 years or whatever. Sometimes those investigations take some time so that we know exactly what we're alleging and can prove the claim.
Kelly, you mentioned you've got investigators in addition to attorneys. Is that right? Working for you?
Yeah, we do have investigators. It's difficult. Like these kinds of cases are documents intensive. We don't represent individuals. He said, she said cases are almost impossible, at this level. So we do have investigators, but most of the cases are driven by the lawyers. They're driven by issuing civil investigative demands, which are basically an administrative subpoena that we can use. They're very broad. They're not subject to the ORCP. They're much broader in scope. Even though we generally bringing state claims, we can ask interrogatories. We can issue subpoenas to third parties and get documents. So we rely more heavily on that.
Is it your default to begin with CIDs?
Yes.
And then if you find something, either move on to an assurance of voluntary compliance or perhaps litigation.
Yeah, multi-states have their own thing, but for an Oregon investigation, what you normally get is a letter from us. Once we've opened an investigation, letting your client know that we've opened an investigation, that we have some concerns, and that we'd like to meet and talk. And if you have a lawyer, have your lawyer contact us. And that initial meeting is just to sort of explain why we're looking. It's an investigation. We're not in litigation. We may be wrong. It may not be as extensive as we think it is. It may be you've already remedied some of the problems. So we're really there to ask and find out. We're not there to kind of hear why we shouldn't investigate you. This isn't the time to litigate your case, but you'll be asked in addition to accept service of a CID. And we usually focus initially on the violations themselves, whatever the scope of the investigation is. We're not looking to, to have some wild, let's find everything they did. We don't have the resources to go on crazy fishing expeditions. You can't bring that as a case later. That's an impossible case to manage. So, we'll note during an investigation if we're seeing additional violations, but they may just become the subject of an injunctive term to get you into compliance. It may not be a proper subject for penalties or restitution. But we'll often save for the same reasons that Nadia is avoiding that in cases. We'll usually focus on the liability first, and then if it's appropriate for restitution, or we're trying to figure out how to calculate violations, then we'll ask for the data about, specific how many, trying to get the individual files or some way to determine how many violations there were. That's kind of a messy business to bury yourself into at the start of a case. And usually there's a series of CIDs, so we can space it out a little bit and get documents going. And at that point, it just looks like a large document.
When you say a series, you mean first set of questions or document requests, and then a second set.
As you go, you start to identify some other issues that are worth spending a little more time at, or you have some more questions. Keep in mind, the state isn't just interested in did that happen, but we were interested in the end of it of fashioning appropriate injunctive relief to ensure that you won't have the same problem. So we also want to know what went wrong and how it went wrong, so we can figure out what needs to happen so that your company doesn't go back to doing the same thing or making essentially the same mistake in a slightly different way. That's important in multi-states as well. If you go look at a multi-state settlement, and those are public once we file them, they're just a lengthy document that often goes into a fair amount of detail about what that needs to look like going forward. So.
Tom, you've talked a little bit about investigations, but if there's anything else you want to add, do it now.
So I guess, so you get a call from a client that says, okay, I got this CID from the Department of Justice. And you can imagine that, 99% of clients will go, this is outrageous. We haven't done anything wrong. We conduct our business in good faith, and as a defense lawyer, that is generally what I believe that companies are doing when they're conducting their business. But so there is a part of the statute that says, we are not in a litigation. When I get a CID, we're not in litigation, right? But your litigator hat comes on and you say, okay, well, I'm responding to document requests. And so I will just object, right? I'll just object to those things, and I'll say, basically what you would do in private litigation is object, and then you'll talk about it and maybe fight about it. They'll narrow things, right? But with the Oregon DOJ or any DOJ, right? They have these investigative tools. You can't just object, right? So you can't preserve an objection that way, right? Because it says something like, the return date or 30 days, whichever is shorter, right? So you're on a clock immediately. So you have then a choice. You can file a petition in court to quash or modify that CID, right? And so you are making you have a choice at that point, because from Kelly's perspective or the lawyers that she works with, they're just, hey, we're just asking some questions. We just want to know. The client is thinking, geez, this is, the Department of Justice. So you really need to talk with your client about, hey, are you going to, at that point, file a petition and potentially start a small war with the DOJ, who you may be able to just resolve this with, so are you going to file that petition and get that court involved? And there's some case law on it. I would say in petitions to fight a DOJ CID, there's not a huge track record of success in the Oregon Court of Appeals with that. So anyway, that's a question you have to ask yourself and counsel your client about. How much do you want to ratchet this up at that stage?
Yeah, and Tom and I were talking about this earlier. We do so many multi-states where we're used to dealing with very large white-collar firms that have AG-specific practices, that have former AG staff, former AGs counseling them, and so they sort of know the rigmarole, and we're able just to get through the process. But often when we get smaller businesses or local businesses, they have a lawyer who's not as experienced, and they go into fight mode, and they don't realize, and it's not just AGs. There's a literature about this. This is common with investigators and enforcers and regulators. You just have a limited amount of time and resources. You have a lot of demands. You're looking for somebody to cooperate. Let's just figure out, what do we need to do to resolve the violations? What do we need to do to make it right? You're going about your work. And you're looking for that level of cooperation. And it is a mitigating factor when we get to the part where we're talking about the dollar amounts. Somebody who was cooperative throughout the investigation, is working to remedy the violations, seems to be acting in good faith. It's more credible when they're not just immediately trying to blow up the whole investigation. It leaves an impression about how committed they are to following the law and taking this seriously. And so it does benefit in the long run. If we have to sue, we're still going to litigate the case. You're still going to fight about everything. But I don't think it's terribly successful. And the case law in Oregon, just like everywhere else for these kinds of administrative subpoenas, is the courts don't interfere with it's not their job to second guess the scope of the investigation or whether we should be investigating. We have a right to try to figure out whether or not the law was violated and how it was violated. We're not in litigation yet. And so Tom's right that they're not very successful at it unless, we were just completely out in left field. There may be some limitations. It's probably more about whether it's public. So.
Okay, let's jump to a couple more specific aspects of the statute. And I'm thinking about, these are both barriers to class actions, but also just barriers to a successful plaintiff's action or not, and particularly ascertainable loss, which is a requirement under the statute for a private plaintiff, and reliance. And Natty, you want to tell us a little bit about how you approach that? And then I want to hear from, and we know that Kelly doesn't have to show this. We can discuss that later, but that's a brief discussion. But on the private side, and Tom, those are obviously important defenses to anybody who faces a UTPA claim.
Yeah. So in our world, ascertainable loss and reliance are very much related concepts, in the sense that whether reliance is required often depends on the nature of the loss or the theory of loss. There's several cases from the Oregon Supreme Court, starting with a case called Scott several decades ago, onto Pearson, which was in 2015, I think, and a relatively recent case called Clark versus Eddie Bauer, that touch on and define this ascertainable loss concept. And the idea is that loss can be anything, right? It's a low threshold, but the plaintiff has to show some loss. I bought the sweatshirt at the outlet store, and I paid $20 for it. Therefore, my loss is $20. That's what the courts call a purchase price theory of loss. But the Oregon courts have also...
And there was a misrepresentation.
Right. But the Oregon, and this is not unique to Oregon, actually. Oregon courts and courts in lots of other jurisdictions, because this all comes from a uniform law that other states have adopted various versions of. Talk about ascertainable loss in terms of theories of loss. It could be, for instance, that the purchase price of the $20 is the theory of loss, but you may also have a claim where you're saying, based on some misrepresentation, I overpaid for that by $5, and therefore the overpayment is my theory of loss. All this to say, I think that the cases, I mean, it gets very confusing, I think, and because whether reliance is required, according to the Pearson case, depends on the nature of loss alleged. As a plaintiff's lawyer, we then plead cases in the alternative. We plead a purchase price theory of loss, but we also plead a price premium or an overpayment or however you want to call it, theory of loss, diminished value.
Let's just make sure everybody who hasn't read Eddie Bauer in the last month remembers. So they advertise these these goods. This is sold out of an Eddie Bauer outlet store, probably the one in Woodburn. But they said these were all originally priced at $50, and they never were priced at $50, and they're selling them for $20. So the defendant says, "Well, look, you paid $20. You knew that was the price of the sweatshirt.
You got what you paid for.
$20 sweatshirt.
Yeah.
You were willing to pay $20 for that." And then they say, "Well, I wouldn't have bought it unless I'd known I was saving $30." That's their claim. And so it was that ascertainable loss. And the court said in that circumstance, yes, it was.
That's a loss. Yeah. But other courts have looked at losses different ways. And in Pearson, the Supreme Court also told us, stop me again if I'm getting, too in the weeds, that whether reliance is required under the UTPA to prove causation depends on the nature of the loss and the violation. If you're saying, for instance, I bought the cigarettes because you said they were light, then there's sort of reliance is sort of logically required to connect the dots between the misrepresentation, these are light cigarettes, and the fact that you bought them. But reliance isn't always required. And so sometimes we plead a theory of loss in a way to eliminate the need to prove reliance. In other words, the need to prove causation between the violation that we allege and the loss that the consumer suffered. All of this is to say that both of these things can be very difficult to navigate, especially in class action cases when you're trying to reduce the number of individualized questions. And so ascertainable loss, I mean, all of these things are also sort of evolving. There's been the Eddie Bauer case was very recent from the Oregon Supreme Court. There are cases pending currently in the Court of Appeals in the Supreme Court where these issues are presented. And so these are all evolving theories and difficult to navigate specifically in class action cases, and results in, like I said, lots of alternative pleading to sort of to get the right combination of elements that makes sense in a class action.
Tom, you want to address that too? And we're going to go to 1:30. We'd like to get some questions if people have some, but let's hear from Tom first on their view of reliance and ascertainable loss.
Sure. I mean, I think, this is right now probably within UTPA law in Oregon, the great divide. You have Natty on one side and me on the other, and the state in the middle. In the sense that, yeah, what you said earlier, Justice Balmer, is correct, right? That the state doesn't have to prove, ascertainable loss, and so the causation to get to the ascertainable loss is not something they have to prove. And 10 years ago, the Oregon Supreme Court issued the Pearson case, which involved Marlboro cigarettes, right? And whether or not consumers were misled about how much the light cigarettes, how beneficial that was, right? So it was, the way I look at that case, there is that connect the dots language, but I look at that case as a pure, that's a misrepresentation case. There was a misrepresentation, and the Oregon Supreme Court said in that case, in a misrepresentation case, you have to prove reliance, right? I mean, that's the only way that loss resulted from the violation, right? And then, so in the last 10 years, there have been a lot of fights about that. Okay, how does that apply in an omission case, right? And then there was the Sharfstein case, which involved BP, and earlier there was a reference to debit charges, and that involved BP service stations, right? And there was a state regulation that said that you had to put, if you're going to charge people for wasn't this specific, but the fact was, hey, if you're going to charge somebody for a debit charge, you know, on their purchase of gas, you need to put it on the sign on the street, right? And so there was a whole fight about that in the Oregon Court of Appeals. That case was only a Court of Appeals case, said that, hey, in this situation of a AG rule under 608(1)(u), you don't have to, a private plaintiff does not have to prove reliance, right? And so how broad, I would say that case is very narrow, right? And I'm sure Nadia would say that case is a broader case, right? Because when you look at, you asked me earlier, you know, what kinds of cases are you seeing, right? Well, in Oregon, you see a lot of cases now brought saying, well, this is a prohibited transaction case, so I don't have to prove reliance. And I would argue that, you know, that you know, Sharpstein was much more limited than Nadia may view it.
Do you want to rebuttal there, Nadia, or you want to move on?
No, we can move on.
Okay. Questions? Who's got Michael? Yeah.
I'm curious what kinds of unforced errors you see most often. So, either for a claim or defense, what would weaken an otherwise strong claim or defense by people who are undecided?
And the question was about unforced errors by the plaintiff, presumably. It could be either party. What sort of mistakes do the lawyers make? Are you worried about your malpractice insurance, Michael? That they can happen that may make it easier for you as the defendant. Let's start with them, and or Nadia as the plaintiff.
I mean, I guess as a lawyer, the thing that, you know, keeps me up at night or wakes me up in the middle of the night is always making sure I preserve everything I can possibly preserve. So, you know, those are the only times I really think about unforced errors is, you know, did I do everything I need to do at that moment?
Yeah, it's hard to. I think my answer might be the same. You know, sometimes I woke up in the middle of the night a few weeks ago wondering if we'd actually delivered the ORCB 32H letter that we intended to deliver, and in fact we had. But there's a few steps in the process like that are small but are really important. But otherwise, we're just worried about preserving the issues.
I will say that there are two common errors that we see.
Yes.
We see folks fail to give the DOJ notice, which you have to do of any UTPA claim.
Ooh,
we regularly see people bring cases under 646, 608(1)(u) when there's no rule. That happens all the time. You don't have a claim. We see national class action lawyers do it. We see local lawyers do it. You don't have a claim if there's no rule.
Say that again.
So the catch-all.
Tell people what U is.
Yeah, so there's a catch-all. It's very attractive when you haven't read the whole statute that says any other act or practice or any other unfair or deceptive act or practice in trade or commerce. So it sounds like anything else that you kind of like a little FTC act, except you have to keep reading down to sub 4, which says that you can only bring a case if our office has issued a rule declaring that practice unfair or deceptive. We see that all the time.
Okay. Anna?
Yeah. My question's for Kelly. Anna's for you. You had some comments about cooperation with the CIDs. Yeah. And for us, sometimes we have smaller clients or local clients in Oregon who the process of going through that disclosure and production is expensive. So we get questions from them about, is there any wiggle room with the state in terms of timing or negotiation of the requests that are in the CID? Could you speak to that from the state's perspective?
Yeah, that's a great question about cooperation on the CIDs when we get them. It's a conversation. It's an investigation. You're not in litigation. We also want to get through it quickly. We know that we may have asked for something sometimes in a way that is going to, be a really difficult way to get the data. And just like if you were in litigation, we want to have a conversation about that. We don't want it to take 6 months either to get the data. Maybe there's something that we ask for that just doesn't make any sense. We'll often agree to just set that request aside and come back. So yeah, you should feel free to talk to us when you get the CID and to have a conversation about the scope or phasing it out or adjusting how we're doing it. And we are mindful of all of that. So
Other questions? Yes, go ahead.
This question is actually for Kelly. My name's Nathan Morales. I work here at Story Reads. And I actually do a fair amount of the privacy cyber work. And one thing that I was wondering is, and this is specifically on like the cyber stuff, like the data breach stuff, right? That sort of is a little bit different than, and I also have worked on a plethora of UTPA, just straight consumer pricing type cases. The data breach stuff seems a little bit unique in that there's this sort of mysterious unknown third party that is actually sort of doing the harm, right? Coming in to hack the individual. And then the theory being that the org in business, right, failed to secure its network in some reason, right? I guess the question is, with that dynamic, right, like with this unknown third party, everybody agreeing, like this unknown third party really is the bad guy that nobody likes, right? How does sort of that dynamic with this empty chair of the really bad person come into play? Like, sort of first, it's similar to Tom's, right? When you're like sort of approaching this company in the investigation space, and then like, how does it impact the investigation itself?
Let me just repeat the question. Repeat the question. It's a data breach question. How does the DOJ approach these issues where there's really a third party that may be more to blame than the person who was the director of the problem or creator of the problem? Anyway.
Yeah. So I mean, with data breach cases, the actual violation is the data breach isn't the thing you're being. It sounds weird, but you're not being prosecuted or you're not being investigated because you were breached. The breach is what gave us notice that you may not have taken reasonable steps, right? You have not employed reasonable safeguards, technical, administrative, and other safeguards that are required by the statute. So there's a statute in Oregon that requires you, if you have personal information is defined by the statute, to employ reasonable safeguards to protect that information. And so when there's a breach, even though it kind of looks like it, we always talk about it in relationship to a breach, you're not being prosecuted because some hacker breached you. The question then is, did you have reasonable safeguards in place? I do think enforcers have to be careful, right? Because you're only looking when somebody's gotten breached. Just because somebody was successful at breaching a company doesn't mean they didn't employ reasonable safeguards. But then that's sort of the thing that comes out of the investigation. Were you doing things right? And, obviously, nobody does everything right. So a lot of it is also just focused on how do we get other structures in place so that that won't happen again. Data breaches are hard, right? The data breaches just keep going up. Companies are all getting breached. We want to make sure they're spending adequate resources on it and that they're taking reasonable safeguards. But it is a little bit after the fact on data breaches. I agree. It's sort of like you got breached, so we pay attention, but we don't know about all the other companies that just haven't been breached yet, that are doing far worse things in terms of, I do think it's an enforcement issue.
One more question. Yes.
I had a question for the officer too.
Yeah.
Mentioned under the prior administration, there was real focus on privacy.
Yeah.
I'm curious for the next administration, the next 4 years, are there different areas that your office is focused on investigation?
The question was about the change in AG's, prior AG, Rosenblum had a particular interest in privacy, and there was a new statute, I think, and they investigated there. And what do you see as the enforcement areas in the coming years?
Yeah, I mean, AG Rayfield has just taken office, and so he'll have an opportunity to figure out what his priorities are and start to set them. And, there's a reality because these things take so long, and we have a really aggressive docket at this point that, enforcement is always limited by capacity. So, the reality is you come into office and we're very busy. We're litigating against TikTok. We're litigating against Meta. We're litigating in Pennsylvania. We're litigating telecom issues. And we have several other cases lined up. We're leading other multi-states. So we have a certain amount of capacity. I don't think it'll make much difference if he has his agenda out there early. But I do think it's helpful as he sets his agenda for folks to pay attention to, where are those issues that are going to take a priority when we're looking at a case. I don't know what they are yet. But I'm sure folks will get a sense of it. They usually talk about them quite a bit.
Okay, well, it's 1:30. We're going to wrap things up here. And so let's give a hand to our panel. Thanks very much. And thank you all for coming and appearing on screen.
And Justice Palmer,
yes.
Thank you very much.
Oh, yeah, glad to be here.